President van der Bellen, Ministers Edstadler and Zadic, President Grabenwater, distinguished members of the Constitutional Court of Austria, ladies and gentlemen here present and online. I stand before you today honoured to represent the European Court of Human Rights at this solemn ceremony to mark your Constitution Day. But also I'm deeply appreciative of the fact that inviting me to address you, you have in turn honoured the court which I serve. And you've even preceded my address with Beethoven's Irish songs, perhaps knowing or not knowing that my Gaelic name, Síofra, means elfin fairy. I'd like to express my particular thanks to President Grabenwater, who first conveyed this invitation to me last December. Through his work at this court, his academic writings, and his contribution to the advisory panel on the selection of Strasbourg judges, he has made a lasting and important contribution to the effective functioning of the convention system. And the Strasbourg judge accompanying me, Gabriele Kuszko-Stadelmeier, who's also the president of Section 4, needs, of course, no introduction to this audience. However, allow me to thank her in front of you, her compatriots, for her remarkable contribution throughout her mandate at the court. The fact that we've served coterminously has been a source of great personal and professional satisfaction for me. As the court's 17th, but first female president, I don't think I reveal any secrets when I say that women don't crack glass ceilings alone. It takes the effort of generations of committed women and men to do this, and it has been my real honour to travel the Strasbourg road together with such a committed professional. The topic of my keynote speech, What Future for the European Court of Human Rights, is intended to inspire reflection in these turbulent times in Europe, marked by the war raging in Ukraine, rule of law backsliding, democratic erosion, and increased societal polarization in many states. It is admittedly challenging to talk about the future, given how sobering is the context in which we meet. While the question of the Strasbourg Court's future has animated extensive institutional and academic debates, I would be very hard-pressed to map the actual success of the various proposals and predictions in one speech, and this morning I promise I won't even try. But the title of my address is deliberately accompanied by a question mark. My remarks may strike you in place as cautious and interrogative, rather than categorical and resounding. However, my intention is not, and I'm not indeed able to provide easy, ready-made solutions regarding the future of the court. In addition, I am and will remain for some time a court president, and I don't wish to trespass into the realm of politics. I should also stress that I wish not to call into question the various reforms introduced before and during what is called the Interlaken reform process, nor, crucially, do I want to call into question the right of individual application which constitutes the cornerstone of the convention system. However, I will walk in the footsteps of some of my predecessors, Presidents Wildhaber and Costa, when I call for genuine and profound reflection on the future of the European Court of Human Rights, beyond mere tinkering, adjustments of judicial compositions, or procedural changes. My intervention today will thus consist of highlights of the key convention developments of the past and an explanation of the realities and the challenges of the present before attempting to offer some elements of reflection for the future. To understand the role and shape of the European Convention system in modern Europe, one has to understand the origins of the European Convention on Human Rights. And in this, of all European cities, it's easy to locate those origins in the atrocities perpetuated on European soil during the Second World War. The Convention was conceived as an early warning system to combat the first signs of totalitarianism. And as Pierre-Henri Thyssen, one of the founding fathers, remarked, the latter doesn't develop in a day. He said the following words: evil progresses cunningly, and democracies are asphyxiated over time. The high contracting parties created an international system for the protection of human rights which was unique of its kind. In the Council of Europe Statute and the preamble of the Convention, they expressed their commitment to three common European values: democracy, respect for rights and freedoms, and the rule of law, whose roots are to be found in the common constitutional traditions of founding and subsequent member states, such as yours. Indeed, as President Graben-Vater mentioned, by elevating the Convention to the rank of constitutional law, Austria has both emphasized its commitment to the Convention, and it has in turn ensured that the work of Austrian courts informs how Convention law develops. In the 1950s, the states also established a court to enforce those values, and thus to give practical and binding legal effect to the rights previously proclaimed in the UN Declaration. The raison d'etre for the establishment of the court in Strasbourg and the legally binding nature of the Convention obligations were beautifully expressed in the following terms in 1949 by Professor Hirsch-Lauterpacht. He said, and I quote, "Even in countries in which the rule of law is an integral part of the national heritage, and in which the national courts have been the faithful guardians of the rights of the individual, there is room for a procedure which will put the imprimatur of international law upon the principle that the state is not the final arbiter of human rights." As many of you know, under the original system, which prevailed for almost 40 years until 1998, 3 institutions exercised responsibility for enforcing the obligations undertaken by the contracting states: the Commission, the Court, and the Committee of Ministers of the Council of Europe. No direct access to the Court was originally provided for applicants, whose complaints first had to go through the Commission. And in the early days, the Court's work was scarce. Between 1959 and 1976, just 18 cases were lodged. For a period of 7 years, no cases were brought at all. The first Belgian judge, in a lecture delivered in 1965, hesitated as to whether he deserved the title of judge at all. And I think I speak for both Judge Cusco Stadelmeier and myself when I say I have no such hesitation. We delivered 4,000 judgments, over 4,000 judgments last year. Yet even during these early years, this fallow period, the Court established some important foundational principles in cases like Lawless against Ireland, which concerned the extrajudicial internment of members in the IRA in the 1950s, or the Belgian linguistics case, in which the Court established its case law on the prohibition of discrimination and the right to education. The 1970s ushered in what was considered a golden era of Strasbourg case law, during which many landmark rulings were handed down. Examples include Golder on the right of access to court, Tyrer on corporal punishment, Airy against Ireland on the establishment of a positive obligation on states to provide effective access to court in civil cases, including via the provision of free legal aid. In these cases, in the 1970s, the Court developed its teleological approach to interpretation, according to which the protection of Convention rights has to be effective. The living instrument document, according to which the Convention can and indeed must be interpreted in the light of present-day conditions. And it recognized a point made by President Graben-Vater that states may owe positive obligations and not simply be bound by an obligation not to interfere negatively with an individual's rights. Throughout the 1990s, with the enlargement of the Council of Europe and the accession of states from Central and Eastern Europe, the docket of the Court started growing. By the end of 1998, with 40 high contracting parties, just over 7,000 applications were pending. The major revolution in the Convention system occurred that year, when a single, full-time European Court of Human Rights was established, putting an end to the European Commission and the filtering system. But this revolutionary change in 1998 also coincided with the progressive appearance of the caseload characteristics that I've just noted, the consequence of the rapid increase in the size, but also in the complexity of the European Convention's espace juridique, or legal space. It became rapidly clear that the reforms enshrined in Protocol 11 were not fully adapted to the changed environment in which the new permanent court had to operate. The increase in the volume of incoming cases by around 10% each year resulted in the steady accumulation of a backlog and, let's face it, growing delays. By mid-2011, having reached 47 high contracting parties, the court was dealing with over 160,000 applications and experiencing growing alarm that the docket would simply suffocate the court and the system. Reforms seeking to reduce the backlog, including greater use of committees of 3 judges or the introduction of single judges to deal with clearly inadmissible cases, were proposed in 2004, but the political masters only succeeded in adopting them in 2010, which was the year that marked the beginning of the Interlaken reform process. And the initial results of those reforms were very promising. The court managed to achieve a decrease in the number of applications. The docket descended to about 65,000 applications in 2015. However, the reduction has been short-lived. From 2016 onwards, due to regional and societal developments, whether the influx of migrants from 2015 onwards, the aftermath of the attempted coup d'etat in Turkey in 2016, the COVID-19 pandemic, or the proliferation of interstate conflicts on our continent, the docket now stands at over 75,000 applications. The court itself, I should stress, has made a major contribution to the reform process by streamlining its working methods to increase efficiency, and through judicial policy decisions such as, for the judges and lawyers here present, the introduction of pilot judgments and what we call the priority and impact strategies. These allow us to get, quite simply, more quickly to the applications which require more expeditious treatment. However, the fact remains that for 25 years since the establishment of the single court, the court has never ceased to grapple with its difficulties posed by the docket, and the fact that it is potentially the court of last resort for over 650 million residents of the Council of Europe legal space, which the court is intended to serve. In the mid-1990s, turning to the present, one of my predecessors, President Reichstal, noted that the Convention had become, and I quote, the single most important legal and political common denominator of the states of the continent of Europe in the widest geographical sense, a constitutional law for all Europe in the field of human rights protection. But the reality is that today, the court forms part of a complex, multi-level system for the protection of human rights, alongside national, constitutional and Supreme Courts of 46 Council of Europe states, as well as the Court of Justice of the European Union as regards 27 of those states. The influence of the Court of Justice thus extends beyond the 27 EU states, and within the 27 EU states, its influence is deepening, given that Article 2 of the Treaty on European Union and the common European values which equally underpin the EU is becoming a driving force in the Luxembourg Court's legal discourse. Our multi-level system for the protection of human rights is thus much more complex than when my predecessor made that statement in the 1990s. In addition, and my German is limited, but I think I did manage to follow the President, the rules-based, multilateral, international order, of which the Court and Convention are both products, is less welcome and more disparaged in some quarters than at any time since the end of the Second World War. Yet let it not be forgotten, as war is waged to the east, that despite the expulsion of the Russian Federation from the Council of Europe in 2022, the Strasbourg Court remains competent to deal with over 15,000 Russian cases pending before it, as well as 5 interstate cases introduced by Ukraine between 2014 and 2022. The message is and should be clear. States cannot unilaterally walk away from their international legal obligations. The jurisprudential relationship with national superior courts of the 46 member states operates under the umbrella of the principles of subsidiarity and the margin of appreciation. According to these principles, the Convention should primarily be applied at domestic level by the national authorities, where necessary by the courts, in accordance with their margin of appreciation. The Strasbourg Court merely offers a last resort, external subsidiary supervision. Central to this relationship with national courts is our jurisprudential dialogue, where we speak through our judgments and sometimes also separate opinions and the odd obiter dictum. This relationship may be marked with agreements or reasoned disagreements. However, as long as the latter reflect what one of my predecessors described as critical loyalty, they too contribute effectively to the protection and development of human rights in Europe. In the context of the enlargement of the Council of Europe following the fall of the Berlin Wall and the dissolution of the former USSR, the Convention system has played and continues to play an absolutely vital role in ensuring democratic change in transitional democracies in Central and Eastern Europe. In relation to states which have joined the EU since 2004, it has played a crucial role in preparing them on the road to accession, but also sanctioning thereafter failures to respect common European values. And the same can be expected to happen in relation to Council of Europe states such as North Macedonia, Montenegro, Moldova or Ukraine, to name but a few, which have been granted EU candidate status. Moreover, the interpretation and application of the Convention as a living instrument by the Court for over 60 years has created a vast body of law covering a broad variety of topics of relevance for international law and our contemporary European legal landscape and the fabric of our societies. Think of the minimum guarantees, which must be enshrined in criminal proceedings in order to ensure fair trials. Think of the vindication of the rights of women, children, the disabled, or sexual and gender minorities, or the development of environmental rights, the protection of privacy and data in our turbocharged digital world, certain aspects of the relationship between employers and employees, or the defense of democracy's lifeblood via rights of expression and assembly and limits thereto. And these are just some examples that I would provide you with this morning. The current position of the Court and the overall Convention system cannot, of course, be separated from the challenges facing the Council of Europe more broadly, as it seeks to protect human rights, democracy and the rule of law in this, our 8th decade. Some of the challenges facing the Council of Europe were recently addressed at the 4th Summit of Heads of State and Government in Reykjavik, which President van der Bellen attended. Prior to the summit, the Court contributed a memorandum identifying what are 3 critical issues: the need for states to abide by their international legal obligations under the Convention and to execute court judgments, the need for sufficient and sustainable resources to allow the Strasbourg Court to exercise its vital judicial mission, and the need to hold states accountable in interstate and conflicts-related cases, even if they've been expelled from the organization. The key political message from the summit, the states' explicit reaffirmation of their deep and abiding commitment to the Convention system and to the Court as the cornerstone of the Council of Europe's protection of human rights, is one which needs to be implemented in practice. But the problem of long-lasting origin, the one which I referred to earlier when I concluded my overview of the past, namely the high number of cases on the Court's docket and the nature of those cases, this problem endures. Leaving aside that up to 80% of the docket is composed of applications concerning questions in relation to which the Court has well-established, if not very well-established, case law, or repetitive cases, almost 20,000 applications are pending at chamber level. These are cases which are either priority or impact cases, meaning they raise issues which must be dealt with expeditiously and which warrant the attention of a 7-judge chamber. And they touch on legal, political, and societal questions of fundamental concern for a given state, for states generally, or across the Convention system as a whole. Yet, according to a calculation published in recent years, the ratio between cases pending and communicated to the respondent governments and judgments rendered by the Court increased from 2.5 to 1 in 2013 to 4.4 to 1 in 2016. How realistic, then, is it to expect a court with 46 judges, very limited legal and material resources, and which performs 4 quite different functions, as I'll explain in a few minutes, to process these cases in a timely manner, while at the same time elucidating and further developing the democratic rule of law and human rights standards required for our age, the 21st century? I was struck when preparing this speech by a recent Belgian judgment, in which our court identified a systemic problem of delay in the length of civil proceedings in Belgium. The court emphasized that the Convention system cannot function correctly in the absence of justice being rendered by independent national courts within a reasonable time. Ipso facto, delay at the level of the Strasbourg Court itself is untenable. But let's not forget that it took over 4 years to render this judgment, which identifies a systemic problem affecting many thousands of litigants. And it's painful for a court president to turn the spotlight on their own court's difficulties. But in my view, it's absolutely essential that I do so. If we break down the court's docket in 2023, we see that the crux of the problem is how to reconcile and execute 4 quite different roles which the Strasbourg court is now called upon to perform. Firstly, filtering a huge volume of inadmissible applications. I'm talking about more than 35,000 applications declared inadmissible or struck out in 2022 alone. Secondly, processing large numbers of more or less repetitive or identical well-founded cases. In 2022, 3 judge committees delivered 796 judgments in respect of over 3,500 applications of this nature. Thirdly, and this is critical, ensuring careful and timely scrutiny and adjudication of cases raising complex and often novel human rights questions, something which Judge Kusko-Stadelmeier presides over every Tuesday. And finally, the court has to manage a record number of interstate and conflicts-related cases because of events occurring on this continent dating back to 2008. One wonders whether Dworkin's idealized Judge Hercules, endowed with extraordinary skills, time and resources, might be a better choice to tackle these difficulties than the mere mortal judges in Strasbourg asked to do so. So therefore, turning to the future, the question boils down to whether, and if so, in what way, we need to rethink the court's role in the convention system to meet adequately not just the challenges of tomorrow, but also some of those which have already arisen today. Some commentators have remarked, quite legitimately in my view, that successive high-level reform conferences on the convention system have been dominated by practicalities, failing to focus on the more fundamental question of purpose. How best should we deploy the Strasbourg Court's scarce resources to ensure that the convention is given maximum effect depends on what one identifies as the core functions and purpose of the Strasbourg Court and the convention. Today, at this solemn ceremony to mark your Constitution Day, I'd like to revisit the debate I touched on in my introduction concerning the court's, and I'm going to put it in inverted commas, constitutional function, and offer it as a path for further reflection regarding the future. And why did I put it in inverted commas? Because let me make very clear, when I use the word constitutional before national constitutional judges, there is no intention or desire to trespass into the terrain of a national constitutional court, like yours, which reviews the constitutionality of laws, oversees the lawfulness of election, decides on conflicts of jurisdiction. I'm not at all advocating that the European Court of Human Rights should resemble national constitutional courts in all significant particulars. The Strasbourg Court's role is and would remain subsidiary to that of national courts. Its jurisdiction is and would remain limited to finding whether convention obligations have been observed. The choice of means to ensure timely and effective execution of Strasbourg judgments is and would remain with respondent states and the Committee of Ministers, and the Court cannot and would not have powers to quash national legislation. But referring to its role in relation to individual applications lodged pursuant to Article 34 of the Convention, the Court has repeatedly explained that it has a dual function. On the one hand, it renders justice in individual cases by way of recognising violations of an injured party's rights and freedoms, and, if necessary, awarding just satisfaction. On the other hand, the Court elucidates, safeguards and develops the rules instituted in the Convention, thereby contributing in those ways to the observance by states of the engagements undertaken by them as contracting parties. In Karner against Austria, on succession to a tenancy of a surviving same-sex partner in 2003, the Court recognised that the provision of individual relief is important under the convention system, but it also stressed that the mission of the Court is, and I quote, to determine issues on public policy grounds in the common interest, thereby raising the general standards of protection of human rights and extending human rights jurisprudence throughout the community of convention states. We can thus differentiate between the Court's constitutional role, whereby it seeks to clarify the interpretation of the provisions of the Convention, safeguarding the achieved level of Convention guarantees, and its adjudicative role, whereby it focuses on individual justice. The guiding consideration is whether the examination of a case goes beyond the particular situation of the applicant and raises issues of general importance for the Convention community of states. The hallmarks of a predominantly constitutional role can most obviously be found in the pilot and quasi-pilot procedures. These are procedures which the Court has developed as a means to identify the structural problems underlying repetitive cases against one or more states and imposing an obligation on those states to address those problems. This procedure allows the Court to select one or more cases for priority treatment and to adjourn or freeze related cases pending the resolution of the leading case. Another example is that we've developed in the last 2 years. The Court has been pursuing a case processing strategy which focuses on what we call impact cases. This too bears the features of a constitutional standards-setting function, as it aims at rapid identification and more expeditious processing of cases which are particularly important for a given state or for the development of the Convention system. And these impact cases can concern a variety of questions, ranging from democratic good governance, the rule of law, protection of the environment, new technologies, equality and domestic violence, or climate change, to name but a few. The Court's constitutional role can also be observed in cases outside the structure of these two formal case processing strategies, such as in the grouping of cases, the prioritization of certain categories of cases, or use of the no significant disadvantage admissibility criterion, according to which cases which do not reach a certain threshold of seriousness need not be examined. In an unprecedented case decided in 2017, a case called Bermit and others against Ukraine, the Grand Chamber of the Court was confronted by a dilemma which placed the question of the Court's role and its purpose front and centre. The case concerned a repetitive legal question par excellence, albeit one with serious consequences for the individuals concerned and for the rule of law, namely non-enforcement of domestic court judgments issued by Ukrainian courts. The Court had already adopted a pilot judgment in relation to Ukraine several years previously, and it had instructed Ukraine in detail on the measures needed to remedy the structural problems at issue. But it had also had to decide on 14,000 individual follow-on cases, and it was being asked to decide 12,000 more. The Grand Chamber considered in this case that it had discharged its judicial function by identifying the systemic shortcoming, finding a violation of the Convention, and providing guidance on the general measures which had to be taken for the satisfactory execution of the pilot judgment. The Court therefore struck this leading case, but also the 12,000 follow-on cases from its list of cases, and it sent them to the Committee of Ministers for solutions to be found at a political level. We need, in my view, to reflect both on the constitutional and adjudicative functions of the Court and to agree upon the steering principles of balance between these two different essential functions. As I said previously, my call for genuine and profound reflection should not at all be read as betrayal of the individual right of application which characterises the Convention system, but it is, in essence, a call for us to protect the Convention system and the Court's role within that system by striking a better balance between the two functions which I've just described. While former judges of the Strasbourg Court, presidents and officials have extrajudicially evoked the need to reflect on and develop the Court's constitutional role, the official discourse of reforms of the Convention system have centred on solutions which would require the Court to adjudicate each and every case reaching it, which at present, as I said, means 75,000 pending cases. Preservation of the Court's adjudicative role, combined with a focus on some procedural and small structural adjustments, have thus taken precedence over consideration of what the Court's constitutional role might better achieve in this, its 8th decade. But to what effect? The Interlaken reforms and innovations certainly succeeded in bringing the system back from the brink. But is it not illusory to think that the Court can systematically render justice in each and every case reaching it when the profound political, economic, rule of law and security crisis of our continent are constantly creating and will continue to create in the future many more individual human rights complaints and dilemmas. Last week, to give you an example, on Tuesday, I delivered a leading Grand Chamber judgment in a case called Yüksel Yalçınkaya against Turkey. The case concerns questions relating to protection from arbitrary prosecution and respect for the right to a fair trial of a Turkish teacher, one of many thousands, convicted of membership of an armed terrorist organization in the aftermath of the attempted coup d'etat. I mention this case in this context because the court is seized of 8,000 similar or identical cases, which it now has to deal with following the Grand Chamber judgment. I'm fully aware of the pitfalls of emphasis on the court's, and I use inverted commas again, constitutional role, which, if not properly managed, could be accused of arbitrary and even politicized selection. My reflections should not be understood as advocating a pure certiorari system, at least not in the form of giving the court absolute discretion over what it adjudicates. The point I wish to make is that the conception of the right of individual application and the reference to the convention system in this context should be understood in a broader sense, where the court is only one, albeit highly important and indispensable element in the overall structure of human rights protection on our continent. In this structure, the court acts not as a court resolving individual complaints, but as a constitutionalist court that elucidates, safeguards, and develops the relevant human rights standards in conjunction with national superior courts. So what can be done to enhance the Strasbourg Court's constitutional role and ensure the future stability of the court and the convention system? Let me start, as a pragmatic female president, with two doables. Firstly, the court, for its part, could delve more seriously into use of the no significant disadvantage admissibility criteria. The record of this criterion has been described by some commentators as dismal, and I think we need to communicate better with the different constituents which the court serves, applicants, respondent states, third-party interveners, and national bar associations. We need to explain how and when this provision could be used. Until recently, the court couldn't reject an application on this de minimis basis unless the complaint had been reviewed by a national court. And this led, to give you one example, and I think Judge Cusco and I were both in the composition, it led to a 7-judge chamber having to deliver a judgment on a parking fine of approximately €25, accompanied, when the applicant complained, with 5 points on his license. And the court found a violation of Article 6 of the Convention because under Bulgarian law at the time, there was no provision for judicial review. But one can only estimate the cost, many times more than the original parking fine and the applicant's €300 cost and expenses, of this European judicial saga. My point is that this is not what the Strasbourg Court is for, and it is not what the Strasbourg Court is needed to do in these turbulent times. The second doable. In our case law, we have often emphasized the important role of lawyers, providing convention protection of their rights and their office under Articles 6 and 10 of the Convention. In a case called Maurice against France, for example, the court held, and I quote, "The specific status of lawyers gives them a central position in the administration of justice as intermediaries between the public and the courts. They therefore play a key role in ensuring that the courts, whose mission is fundamental in a state based on the rule of law, enjoy public confidence." But the court added, that special role of lawyers as independent professionals in the administration of justice entails a number of duties. Given that the court rejects, on average, approximately 37,000 applications each year, with approximately 31,000 applications rejected by single judges for various procedural irregularities, national bar associations could play a much greater role in ensuring that lawyers also understand their duties when it comes to their clients lodging applications in Strasbourg. Moving on to a more substantial change, the less immediately doable. At the level of the member states, and it is after all the member states who are the principal institutional actors controlling the future of the court and the convention system, reflection could be carried out to devise institutional mechanisms for the court, allowing it to further filter cases which have constitutional or impact relevance. Such filtering would not be purely discretionary, but would depend on clear criteria for identifying cases of general importance for the Convention community of states and/or for a respondent's legal system. The filtering in question would also differ from a purely certiorari procedure in that prima facie meritorious cases not falling within the constitutional or impact categories wouldn't be rejected but could be referred to the Committee of Ministers for the finding of a solution to the applicant's complaint in cooperation with the authorities of the respondent state and in accordance with the well-established case law of the court. Substantial reforms of this nature might also look to an enhanced role for what we call non-judicial rapporteurs, provided by Article 24 of the Convention, who operate under the authority of the President and who form part of the registry. Additionally, or alternatively, a preliminary non-judicial layer for the examination of cases, performing a similar role to the former Commission but attached to the Court, could be competent only to dispose of repetitive cases and cases subject to well-established case law. Relevant cases could always be referred back to the Court if it was found that a judicial examination by a body of 3 or 7 judges was necessary. For its part, the Court, I think, can do more with pilot and quasi-pilot judgment procedures, and I'm conducting an internal reflection on how we might do better in this regard in future. The purpose of these changes, which go to the role and function of the Court, is to allow 7-judge chambers to concentrate their judicial efforts on cases of systemic and constitutional reference. A fundamental prerequisite for a functioning convention system based on constitutional pluralism is for national superior courts to act as faithful guardians of the values underpinning the convention system. They have the task of ensuring that the convention is duly implemented and embedded into domestic legal orders. Given that we have over 75,000 cases pending, the system of shared responsibility is clearly not working in all states to the relevant level it should. However, on a more positive note, as I approach my conclusions, 70% of our pending cases hail from just 4 states out of 46, namely Turkey, Russia, Ukraine, and Romania. Austrian applications represent, in contrast, only 0.12% of our current docket. This points to the fact that for many of the 46 states, embeddedness has been achieved, ensuring that the Strasbourg Court only intervenes exceptionally, albeit when it does, in cases such as Kurt, X and others, Maslow or Schalkenkopf, the impact of our judgments is far-reaching, even in cases in which we find no violation. In these and other Austrian cases, the Court has contributed significantly to the development of convention case law, and Austria's record executing court judgments signals commitment to the system, its authority and its value, as well as simple, necessary respect for the rule of law. Distinguished guests, when asked to deliver an address to mark this important day in your legal and political calendar, I did deliberately choose a topic which would make the speaker work in advance and the audience work on the day. Given that I have made your minds work hard this Monday morning, allow me to conclude quite shortly by referring to the terms of the Plenary Court's memorandum on the occasion of the 4th Summit. In this memorandum, the Court's 46 judges recalled the decisive role played by the Council of Europe and by the Court for over 7 decades, seeking to maintain high standards of democracy, human rights, and respect for the rule of law in the Member States. Our collegiate body concluded then in a manner which I consider I cannot better, and therefore I turn to the words of the College of 46 Judges. I quote, "As war rages on European soil, Council of Europe member states should not lose sight of what the convention system is intended to do. It serves as an early warning system which seeks to prevent the erosion of democracies. We cannot either lose sight at this critical point in Europe's history of the Convention's special character as a treaty for the collective enforcement of human rights and fundamental freedoms. And this perhaps our most important message. and of our profound responsibility to pass on this unique international protection mechanism to future generations. In this solemn spirit of responsibility, tinged with a bit of hope, I wore green today on purpose, I conclude today's address and thank you most warmly for your invitation. Vielen Dank.